Welcome to our webinar on fee disclosure, what you need to know for smooth sailing. My name is Barbara Lewis, and I'll be moderating today. We have an exciting presentation that will last about 30 minutes. If you have any questions during the webinar, you can type them into the panel on the right side of your screen. And if we have time, your questions will be answered at the end of the presentation, or if we don't have time, via email. The slides of this webinar will be available on the ERP and Wagner websites. Let me introduce the host of the webinar, Ed Repper, founder and partner of ERP Actuaries and Consultants. Ed has over 15 years' experience in the retirement plan industry. He is an enrolled actuary, and he focuses on retirement plan design and administration. Welcome, Ed.
Thank you, Barbara. Thank you for that lovely introduction. Just a quick background of our firm, ERP Actuaries and Consultants. We're an actuarial/TPA firm. We have two locations, one in Midtown Manhattan, the other in Melville, Long Island. The firm was established in 2003. I am one of the founding partners, and we currently administer over 300 both defined contribution and defined benefit pension plans. And we're rounded out by a staff that includes credentialed members of both the 401k or the DC department, as well as the actuarial department.
Thank you, Ed.
Next slide.
Joining Ed is Marcia Wagner. The Wagner Law Group was founded by Marcia in 1996. They have offices in Boston, New York, Florida, and San Francisco. And the firm specializes in ERISA, employee benefits and executive compensation, estate planning and administration, and employment, labor, and human resources law. Marcia is a renowned national ERISA attorney. She's a frequent speaker at national conferences and a prolific author of many articles and books. In fact, she had 2 books that came out last month. You can find more about her articles and books on her website at wagnerlawgroup.com. For several years, Marcia was on the IRS Advisory Committee on tax-exempt and government entities, where she served as the Employee Benefits Subcommittee. She provided advice and consultation to the IRS on pension matters. Welcome, Marcia.
Thank you. It's a pleasure to be here.
So I know we have a lot to cover. I just wanted to talk to you a little bit about what we will be focusing on today. And before we start, why don't we talk a little bit about the survey results? And actually, this webinar is a genesis of a survey that was done. And Ed, why don't you tell us a little bit about the results that you saw in the survey?
Yeah, thank you, Barbara. Yes, we were a bit surprised about the results. You know, we had anticipated certain things, that a little bit more activity in certain areas, and that we were quite a bit surprised about. One of the things that we identified, that about a half of the respondents haven't developed a strategy for informing the plan sponsors about the fees, and about 2/3 have no strategy for informing the participants in the plan.
And that's surprising, because with all the information that's out there, I found that statistic very surprising.
Yes, indeed, because there has been a lot of publications, there has been a lot of messages sent with regard to this issue. So those results were a bit surprising. About almost half were actually concerned about the fee disclosure regulations. So most people are aware of them, and it turns out that almost half of those folks who were surveyed, or who responded to the survey, were actually concerned about the fee disclosure regulations and how that would affect their businesses. Respondents indicated apprehension about participants' reaction when they learn about fees. This is interesting, because actually less than half were concerned about the fee disclosure regulations, but a significant number of the respondents indicated that they had some serious concerns about how the participants would react when they learn about those fees, learn about the fees and the new that are actually going to be disclosed under the new regulations.
So after you did the survey, then you decided that this would be a good topic to have as a webinar, and invited Marcia to join you today.
Right, we're actually very fortunate that Marcia Wagner was able to join us and give us her take on the new disclosure rules and try to get us all up to speed on what this can mean to us.
And actually, we had hundreds of people who have signed up for the webinar, so this is proving to be very topical and certainly very popular. So, Marcia, let me turn it over to you at this point, and go ahead and tell us about the free disclosure regulations.
Absolutely. Again, it's a pleasure to be here. Retirement security continues to be a very major priority for this White House. The Obama administration's position is that the current system does not provide sufficient retirement security for millions of Americans, and it is pushing for significant regulatory changes, primarily but not exclusively through the U.S. Department of Labor, particularly with respect to fee disclosure. So let's now begin on that and what that means. Okay? Great. Now, on October 14th, 2010, the DOL finalized its regulations concerning fee and investment-related disclosures that must be provided to participants in 401k and other defined contribution plans with participant self-direction. That means, by the way, that defined benefit plans and employer-invested money purchase pension or profit-sharing plans are, in fact, excluded. Moreover, anyone that is eligible to be in a plan, even if they do not participate in a plan, needs to receive all of this information. And this might prove to be somewhat challenging in the 401k plan arena, where many participants do not, in fact, make elective deferrals each and every year, but need to receive, and now you'll find, a lot of information on an annual and on a quarterly basis. Next slide, please. Next slide, please. Very good. Now, under the DOL's final regulations, participants must be furnished general information about the plan annually, including an explanation of how participants may give investment allocation instructions and information concerning the plan's investment menu. Plan participants must also receive an annual explanation of the general administrative service fees which are charged against their accounts, as well as any individual expenses charged for individualized services like plan loans, hardships, quadros, etc. Participants must also receive certain information on a quarterly basis. They must receive statements that include the quarterly dollar amounts actually charged to their participant accounts as general administrative service fees, as well as individual expenses. Now, this is interesting. So say, for example, there's a financial advisor that charges 100 basis points. Say, for example, a plan participant has a $100,000 account balance. Every quarter, that plan participant will receive or must receive a statement saying $250 is being paid to John Doe Financial Advisor. You plan sponsors out there in the audience need to make certain that your plan participants understand what they're paying for and who this John Doe is and the services that he renders. Now, the annual and the quarterly fee disclosures for general administrative services and individual expenses only apply to the extent such fees are not already reflected in the total annual operating expenses of the plan's investments. So, for example, if a service provider is wholly compensated through indirect compensation flowing from the plan's investment funds, for example, it's fully paid by 12b1 fees, then the exact amount that he or she receives does not have to be depicted this way, but just merely notated and described as such. Next slide, please. Plan participants must receive certain fee and performance-related information relating to the plan's various investment alternatives in a comparative format, which the DOL has provided a model comparative chart for. The comparative information which must be provided includes the name and the type of the investment option, investment performance data over different periods of time, benchmark performance data, fee information, including both the total annual operating expenses of each investment alternative and any shareholder-type fees, and an internet website address at which additional information can be obtained. Next slide, please. I'm sorry, that is the correct slide. Stay there. Now, on request, participants must be provided with copies of fund prospectuses, shareholder reports, and related financial statements. The annual disclosures required under these regulations may be provided separately or as part of the plan's summary plan description or the participant benefit statements. The required quarterly statements may also be provided separately or as part of the plan participant's benefit statements. Now, mind you, all disclosures must be written in a manner calculated to be understood by the average plan participant, which, mind you, might not be easy to do. Now, a plan sponsor's compliance with the new disclosure rules will not relieve it of any fiduciary duty to prudently select and monitor the plan providers and investments. It's just basically another responsibility added on to what the plan sponsor needs to do. To comply with the applicable investment disclosure requirements under the 404C regs, now participants simply need to receive an annual and quarterly disclosure as required under new regs, which makes life a little easier because the full prospectuses that had to be disclosed for 404C compliance is no longer required. The new disclosure requirements are in general applicable to plan sponsors for plan year starting on or after November 1, 2011, with an extended effective date for calendar years being August 30th of 2012. Next slide. Yes, good, very good. Thank you for changing the slide for me. Now, the impact of the new regulations are going to be, in my humble opinion, quite significant. Given the detailed level and the comparative nature of the disclosures that will be required to be provided to participants, many are going to, well, frankly, scrutinize their plan investments and fees. And the enhanced disclosures may prompt some to pressure plan sponsors and to ask some hard questions, especially because, frankly, many plan participants had been led to believe, for whatever reasons, that their 401k plans were, and I put this in quotes, a free benefit. Now, advisors can and should help plan sponsors prepare. How? They should help plan sponsors prepare for the new requirements by helping them complete or completing for them the investment portion of the comparative chart, i.e. the investment and the benchmark performance data. They can and they should discuss the new disclosure rules with the plan's record keeper to determine the extent to which the newly mandated fee disclosures are, or more likely are not, currently being provided to plan participants. The advisor can and perhaps should also meet with plan participants in general information sessions to explain to them and educate them as to what they're going to be receiving, what it means, and how their 401k plan operates. Again, a lot of the terms might not be familiar to plan participants, and there should be some educational outreach. And finally, if the plan sponsor is concerned about the potential reaction and scrutiny from participants, advisors can and should work with the sponsor to show that a prudent review process is in place with respect to investments and services rendered. And that is the best protection against fiduciary liability and also, of course, lawsuits. The next part of fee disclosure is what has to be disclosed not to plan participants, which we just discussed, but rather what plan vendors, service providers, really need to disclose to plan sponsors. Now, there has been a great deal of discussion surrounding the so-called hidden payments flowing from the plan's investment to its service providers, i.e. record keeper, pension consultant, etc. Plan sponsors are undoubtedly aware of the hard dollar fees invoiced directly to the plan or to the plan sponsor, but they may not necessarily understand that the service provider can also receive large amounts of indirect compensation flowing from the plan's investment funds and the managers of such funds. Therefore, a plan sponsor could conceivably select what appears to be, again in quotes, a free administrative service for the plan without understanding that the provider's compensation was being passed on to the participants in the form of higher embedded costs of the plan's investment funds. A plan sponsor's ignorance of the fact that administrative service providers can receive such indirect compensation creates a potential conflict of interest for the administrative service provider. By steering plan clients to the arrangement with the highest level of indirect compensation, the provider is presumably able to receive fees in excess of what plan clients would otherwise be prepared to pay had they known the true cost of the services, or at least that is the concern. Ironically, the arrangement with the highest level of indirect compensation may be the most attractive to an uninformed plan client because it would have lower hard dollar fees, creating the false impression that this service arrangement is the cheapest for the plan, as in the example you see on your screen. Now, mind you, revenue sharing among a plan's investment and service providers is not prohibited under ERISA, but without the full disclosure of the indirect compensation paid to the plan service providers, the plan and its participants might end up paying fees that are unreasonable, resulting in a breach of its fiduciary duties under ERISA. Now, to address these concerns, the Obama administration, frankly, wants to improve the transparency of 401k fees to help workers and plan sponsors. Now, it should be noted that the administration's policy objective to improve fee transparency in the 401k plan industry has been growing in political momentum over several years. In fact, in 1997, the DOL held a hearing on 401k plan fees, which appeared to have been in direct response to several consumer magazine articles criticizing the size of such fees. In 1998, the DOL published a 19-page booklet entitled A Look at 401k Plan Fees for Plan Participants and a 72-page report entitled A Study of 401k Fees and Expenses for Plan Sponsors. Unfortunately, the DOL's efforts to persuade plan sponsors and plan participants to ask the right questions about 401k fees has failed. In light of that failure, the DOL is now mandating service providers to disclose answers to questions the DOL believes plan sponsors should have been asking all along. Next slide, please. Next slide, please. Very good. So basically, the final regulations define who is a covered plan for which disclosure needs to be provided. And that is effectively all employee pension plans with certain exclusions for IRAs, SEPs, Simples, and legacy 403B plans. Next slide, please. So then the question becomes, well, what has to be disclosed to whom and when under the 408B2 new requirements? So first is the who. A covered service provider who needs to make this disclosure would include the following: any fiduciary to a plan, be it under ERISA or the Investment Advisors Act. 2, anyone providing record-keeping or brokerage services to self-directed individual account plans. And 3, Anyone who provides services within a broad list of categories that are going to receive indirect compensation, including, by way of example, investment consulting, accounting, auditing, actuarial, legal, appraisal, etc. So, what then has to be disclosed? Only two things, for all the sound and fury of 408B2, need to be disclosed. One, what services is the covered service provider rendering? And two, how is it compensated and what is it receiving? So, with respect to services, a covered service provider must disclose in writing to the plan sponsor all services that it is going to be providing to the plan, and it has to disclose whether it will be providing such services as a fiduciary, either under ERISA or under the Investment Advisors Act of 1940. Unlike the proposed regulations, the final regs do not require a formal written contract delineating these disclosure obligations, but I think it's highly recommended that there be a formal contract. In addition, the final rule eliminates required disclosure of conflicts of interest on the part of the service provider. The reasoning for this change is that the expanded disclosure of compensation arrangement definition with parties, I think, provides a better tool to assess the service arrangement's reasonableness as well as potential conflicts of interest. Now, there's a significant distinction on how disclosure must be made if something is direct compensation or if something is indirect compensation. To clarify, direct compensation means compensation as received from the plan or, in certain instances, the plan sponsor. Indirect compensation is defined as compensation received from a source other than the plan or the plan sponsor. So, for example, 12B1 fees, investment management fees, finder fees, float income, soft dollar, revenue sharing, etc. Now, covered service providers are required to disclose all direct and indirect compensation they receive. In the case of indirect compensation, the service provider must also identify the services for which the indirect compensation is going to be received, as well as the payer of that indirect compensation. Next slide, please. The compensation may be expressed in any way that a reasonable plan fiduciary could evaluate what the person is receiving. And that can be a dollar amount, a formula, a percentage of covered plan assets, a per capita charge, etc. Disclosure must also include a description of the manner in which the compensation will be received, such as whether it will be billed or deducted directly against the participant account. Compensation set on a transaction basis, so for example, commissions of soft dollars, or charged directly against the plan's investments, so for example, 12B1 fees, and paid among the covered service provider and any affiliate must be separately disclosed. The services for which the compensation is to be paid, the recipient and the payor must be clearly identified because it's indirect compensation. Now, other types of compensation do not require that separate level of disclosure. Next slide, please. All of the required disclosures need not be contained in the same document and may be, to a very large degree, provided in electronic format. However, the DOL has indicated that it is likely to introduce a potentially significant change that will be required in the future to make information provided in multiple formats more accessible to the plan sponsor. This new provision will likely require service providers to furnish a guide or a disclosure summary to assist plan fiduciaries in reviewing disclosures. The DOL attached a sample guide to the final regs as an appendix and has a reserved place in the final regs to contain such a requirement. The sample guide included with the regulations contained 2 columns. Information to be listed in the first column would include the services to be provided, various categories of service provider compensation, and fees and expenses relating to investment options. The second column would show where the services listed in the first column are to be found in the service agreement, or where information relating to the investment fees and expenses can be accessed on the internet. Therefore, such a guide would enable plan fiduciaries to locate compensation information disclosed through multiple and/or complex documents in a more readily ascertainable fashion. Next slide, please. Disclosure of the information regarding compensation or fees must be made reasonably in advance of entering into, renewing, or extending the contract for services. During the term of the contract, in general, any change to the previously furnished information must be disclosed within 60 days. Errors or omissions made in good faith must be disclosed within 30 days of the service providers acquiring knowledge of this good faith error or omission. Next slide, please. As under the proposed 408B2 regs, the final rules provide that the service provider's failure to comply with the disclosure obligations will result in a prohibited transaction with a significant, and I would say draconian, excise taxes that are applicable to that. Now, because the prohibited transaction rules would really hurt a plan sponsor or similar plan fiduciary, the DOL has a separate class exemption that would provide relief for the plan fiduciary. To qualify for this relief, the plan sponsor must take corrective steps with the service provider after discovering the disclosure problem by requesting in writing, and that's important, in writing, the correct disclosure information. If the service provider fails to comply within 90 days of this request, the plan fiduciary must notify the DOL within 30 days. And that way it will not be considered to be responsible for the prohibited transaction. So plan sponsors out there, be aware of these very hard and fast deadlines. These rules will be effective as of July 2, 2012. Many people think it's July 1, but July 1 happens to be a Sunday. I do not believe, in good faith, this will be extended again. So everyone should be getting ready for these rules. Next slide, please. So vendors should be well on their way to creating this information for the July 2nd deadline. Now, investment vendors, including platform providers, are responding in very different ways. And plan sponsors out there, you need to know what you're going to be receiving, and you might want to take the bull by the horns and call your vendors to figure this out. Some providers are simply disclosing the fees for their bundled services without itemizing the separate fee for each component service. However, this disclosure technique will not work in all instances, including if there's bundling for record keeping. Now, if there's no explicit fee for record keeping, a reasonable good faith estimate is in fact mandated. Some providers are merely disclosing their own fees without reference to other providers. This technique will work if the other service providers to the plan are covered providers and not subcontractors. A covered provider is responsible for the disclosure of compensation it pays to its subcontractors. Plan sponsors out there, you need to be aware of this. Some providers are subcontracting their disclosure responsibility in total. While a covered provider is ultimately responsible for providing the disclosure, a covered provider can, in fact, hire a subcontractor to assist in fulfilling its disclosure obligations. In light of the different disclosure practices evolving among the investment vendors, a financial advisor to the plan sponsor should determine who's responsible for making which disclosures. In fact, it should quarterback this disclosure so the plan sponsor client knows what they will be receiving and from whom and when. Next slide, please. Plan fiduciaries have always had a duty to prudently monitor each provider's compensation and to ensure that the plan fees are in fact reasonable. Therefore, once plan sponsors begin to receive the newly mandated fee disclosures, they will have an affirmative duty to review this information and to prudently evaluate the direct and the indirect compensation. Unfortunately, due to the complexity of many plan arrangements, many of which involve multiple parties, subcontractors, and different types of indirect compensation, plan sponsors will need, in many cases, help, assistance in understanding this information. Financial advisors can and should play a key role in helping plan sponsors interpret the disclosures, including with the 408B2 information. A qualified investor can really help a plan sponsor determine if its fees are unreasonably high in light of the quality of the services provided, and the advisor can assist the plan sponsor in investigating, if necessary, alternative plan services and investment arrangements. Now, that is a lot of information that I've just provided to you. Hopefully it is helpful to you given these new regulatory regimes. And with that, I turn this over to Ed once again. Thank you very much.
Thank you, Marcia. That was a very detailed and very informative presentation, and I'm sure everybody got you got a lot of information and your take on the effects of these regulations. If you have any questions for either Marcia or me, Ed Repper, please, you can email us, and you can see that on the website, on the presentation. My email address is located erepper@erpactuaries.com, and Marcia Wagner's email is marcia@wagnerlawgroup.com.
Thank you,
Next
Ed and Marcia. That was just great. And thank you to everyone for attending this webinar on fee disclosure. We had a couple of questions on the recording of the webinar, and it will be available on the ERP and Wagner websites. Please feel free to contact either Ed or Marcia as a resource, or if you'd like them to give a presentation to your firm or organization. We hope you'll be back for our next webinar. Thank you very much.